Hello, everyone. Today we will be discussing sources of obligations under the Philippine law. In our previous video, we have discussed and explained carefully the legal definition of obligation as defined by Article 1156 of the Civil Code of the Philippines. If you have not yet watched the video, I will be putting a link here. I highly encourage you to watch it too for you to have a better understanding of this matter. Actually, madali lang ang topic na 'to. Kayang-kaya niyo na nga kung tutuusin. Pero since marami pa rin ang naghahanap, anyway, i-discuss na rin natin, okay? So, simulan na natin. Article 1157 of the Civil Code provides that obligation arises from number 1, law, next, contracts, 3, quasi-contracts, 4, acts or omissions punished by law, and 5th, Quasi-Delicts. So, simply put, yung Article 1157 enumerates the sources of obligations which are, sabi nga, law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Kung tutuusin, isa lang naman talaga ang ultimate na source ng obligations. Ito ay ang batas mismo, di ba? Kumbaga, lahat ng ibang sources gaya ng contracts at quasi-contracts ay nanggagaling din mula sa batas. So the ultimate source of obligation is the law. However, there are 5 proximate sources of obligations. And ito yung i-discuss natin today. So, first, law, or what we call obligation ex lege, legal obligations. Ang pinakaunang source ng obligation ay batas. Ang tawag dito ay legal obligations. Ito ay mga obligasyon na direktang ipinag-uutos ng batas mismo. Isang magandang halimbawa nito ay first, yung obligation to pay taxes na itinakda ng National Internal Revenue Code. Isa pang halimbawa is yung obligation to support one's family na makikita rin natin sa Civil Code of the Philippines. Okay? Article 1158 provides that obligations from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this code. So, simplify na lang din natin to provisions na to. It only means that obligations should be expressly provided by law. Dapat meron talagang batas na nagde-define sa obligation na yan. Otherwise, they cannot be presumed to exist. Hindi pwedeng presumption lang. Kung wala talaga, then that is actually not demandable and enforceable. They are not presumed because they are considered a burden upon the obligor. Nag-i-impose siya ng obligation, di ba? And so, dapat clearly stated. To be demandable, they must be clearly set forth in the law. Like nakasaad talaga at makikita mo talaga sa batas. If it's our obligation to pay tax, then andun siya dapat sa tax code ng Pilipinas. Okay? Malinaw naman, di ba? So, wag na nating complicate pa ang mga simpleng bagay. Proceed na tayo. Lipat tayo sa pangalawang source ng obligations, which is contracts. So Article 1159 provides that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. So sabi ko nga, the next source of obligations, contracts. Etong article na to, itong provisions na to, speaks of the contractual obligation or yung obligation that arises from contracts or voluntary agreements. Yung mga tinatawag natin na obligation ex contractual or contractual obligations. Well, it was provided in the law, particularly Article 1159, na yung obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. So, to simplify again, contracts are the law between the parties. Hence, it must be complied with in good faith. So, anyway, what does compliance? Palaging sinasabi, complied with in good faith. So, ano nga ba yung sinasabi or tinatawag na compliance in good faith? Anong ibig sabihin yan? It refers to the compliance or performance in accordance with the stipulations or terms ng kontrata na ginawa nyo. Kung ano ba yung mga stipulations and terms na nakasaad sa agreement or sa contract nyo, dapat i-comply nyo yun according to that terms. So, if hindi pa malinaw, uulitin ko ha, yung mga obligations na mula sa kontrata ay pinamamahalaan, kumbaga, governed ng mga kung ano man yung kasunduan ng both parties. Kapag naayos na, may valid na kontrata, yun ay may bisa ng batas between the parties. So, dapat sundin ninyo kung ano man yung nandoon. Sundin ng tapat, compliance in good faith. Kung ano man yung mga terms and conditions or stipulations na nakasaad sa kontrata, dapat sundin kasi yun ay merong force of law. Obligatory force of contracts, meaning. At dahil nga the law recognizes the obligatory force of contracts, then dapat walang sino man sa parties na yon ang mag-i-evade or hindi sumunod kung ano man yung napag-usapan. But take note, okay, eto lang, importante rin to. Although contracts have the force of law, it does not mean that contracts are above the law. Contracts are within the limitations imposed by law pa rin, okay? Sabi nga ni Article 1306, which states that a contract is valid if it is not contrary to law, morals, good customs, public order, and public policy. So, meaning, although meron siyang force of law, kailangan pa rin naman mag-comply siya sa law. Hindi siya dapat against the law. In order to have a valid contract, it should not be against the law. Okay? In the eyes of law, a void contract does not exist. Huh? Okay? No obligation will arise from it because in the eyes of law, pag void yung contracts, it does not exist. Wala siyang, void yung existence niya mismo. Okay? Halimbawa, in a contract whereby Pogi will kill Ganda in consideration of 1,000 pesos to be paid by Beauty. This is void and non-existent. Because, bakit? Killing a person is contrary to law. So, meaning, yung contract na yan ay void. Hindi siya valid and so it would not become a source of obligation. To reiterate, in the eyes of law, a void contract does not exist and no obligation will arise from it. That's it. That's Article 1159. Let's proceed to another source of obligation, Article 1160. Obligations derived from quasi-contracts shall be subject to the provision of Chapter 1, Title 17 of this book. Anyway, quasi-contract or obligation X quasi-contractual.
Actually, this refers to obligations which arises from lawful, voluntary, and unilateral acts, and which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. Okay? No one shall be unjustly enriched or benefited at the expense of another. Tandaan nyo yan. Anyway, there are two kinds of quasi-contract. The negatium gestu and celotio indebete. Unahin natin si negatium gestu. Negatium gestu, or otherwise known as unauthorized management. This This takes place when a person voluntarily takes charge of another's abandoned business or property without the owner's authority. In this case, the owner shall reimburse the gesture for necessary and useful expenses incurred by the latter for the performance of his function as a gesture. Actually, mas madali siyang intindihin through example kaysa sa pabalik-balik natin i-explain, okay? Ganito siya. Halimbawa, si Beauty, a farmer, meron siyang 10-hectare agricultural land. Lumipad siya, pumunta siyang USA. Now, during the time na nandun siya sa Amerika, nagkaroon ng typhoon. And the typhoon devastated the land owned by Beauty. Pero before pa man dumating yung typhoon, before pa man nagkabagyo, yung bagyo is naglandfall dun sa mismong property ni Beauty, si Pogi, kapitbahay ni Beauty, nag-hire siya ng 6 na farmers, okay? To harvest the palay planted on the land of Beauty. Now, in order to do that, etong si Pogi, di ba nag-hire siya ng tao na maka-harvest, and so, naka-incur siya ng pambayad. Binayaran niya yung mga tao, gumastos siya ng 6,000 pesos kasi 6 na tao. Granting binigyan niya ng tag-1,000. So what is the obligation of Beauty upon arrival from the USA? The obligation of Beauty upon arrival is to reimburse Pogi the amount of 6,000 pesos, which is equal to the necessary and useful expenses incurred by Pogi para ma-harvest yung palay ni Beauty. And the reason for this is because she must not enrich herself at the expense of Pogi. Okay? Okay na ba? So, punta tayo kay Solutio and Debete, the second type of or kind of quasi-contract. Si Solutio and Debete naman, or undue payment, this Solutio and Debete takes place when something is received when there is no right to demand it, and it was unduly delivered through mistake. So, kung meron kang natanggap through mistake, kasi wala ka naman sana talagang karapatan over it, then you have the obligation to return the thing, okay? An obligation to return the thing arises on the part of the recipient. Okay, so we just have to remember and keep in mind the two requisites. Okay, first, there is no right to receive the thing delivered, and second, the thing was delivered by mistake. First, there is no right to receive, and second, it was delivered by mistake. So, example, Pogi owes Ganda 10,000 pesos payable on December 25, 2020. Before December 25, 2020, Pogi, thinking that the obligation was already due, he paid Ganda the full amount of the obligation. What is the obligation of Ganda? Ganda's obligation is to return the amount paid because the obligation is not yet due and demandable. And the obligee, which is Ganda, has no right to demand it. Okay? Another example, Pogi owes Ganda 10,000 pesos. However, Pogi paid Beauty. Okay? Si Beauty yung binayaran niya instead of si Ganda. So, what is the obligation of Beauty? Beauty has an obligation to return the payment. The rule is also true if, halimbawa, eto, napaka-common scenario. May pera ka, 500 pesos. Pinabarya mo sa tindahan. Okay? Ng tegwa 100 pesos. Now, instead of giving you 100 peso bill, yung tindera is nagkamali. By mistake, she gives you 100 peso bill. And so, what is your obligation? You have an obligation to return the extra 100 pesos. Okay? Yun yung quasi-contract or undue payment, solutio and debete. Madali lang siya. So, Feel ko malinaw na. Okay? Now, if you are wondering what is the difference between a contract and a quasi-contract, just keep in mind that in a contract, consent is essential requisites or requirement for its validity. Di ba? Para magkaroon ng kontrata, dapat merong consent ng dalawang parties. Or kung tatlo, din ang lahat ng parties. Pero when it comes to quasi-contract, ano yung nawawala? Yung consent. The consent is presumed. Pinipresume na lang natin na merong consent kasi wala siya. Like kung sa unauthorized management, nasa yung example natin kanina, nasa abroad si Beauty. And now, so some examples of quasi-contract that are provided for under the Civil Code. Tingnan nyo na lang din, basahin nyo. Kasi ito yung mga examples ng mga quasi-contracts na nasa batas. Article 2164. Yan. Kayo na magbasa. Okay? Let's proceed with Article 1161 as of now. Para, okay, malapit na nating matapos. Wait, mag-charge na ako. I'm so low, but... Okay. Article 1161. Civil obligations arising from criminal offense shall be governed by the penal laws, subject to the provisions of Article 2177 and the pertinent provisions of Chapter 2 Preliminary Title on Human Relations and of the Title, anyway, and of the Title 18 of this book regulating damages. Civil liability arising from crimes or delicts. Okay? Or ito yung mga obligation ex maleficio or ex delicto. Civil obligations arising from criminal offenses or those that arise from civil liability which is the consequence, resulta ng pagkakaroon ng mga criminal offense. I would like to bring your attention to Article 100 of the Revised Penal Code, which provides that every person criminally liable for a felony is also civilly liable. So, ibig sabihin, commission of a crime is a source of an obligation. So, if a person therefore is guilty of a crime, he must not only be imprisoned, but he shall also answer for damages as a civil obligation. Okay? So, to reiterate, if you commit a crime, you are liable both criminally and civilly. So while the act or omission is felonious because it is punished by law, the criminal act give rise to the civil liability as it caused damage to another. Now, an exception to this rule is when there is no private offended party. Anyway, so the criminal liability includes, ito yung mga, ano-ano nga bang mga civil obligations na kasama sa criminal liabilities. First, we have restitution. Second, we have reparation of the damage caused. And third, we have this indemnification for consequential damages. So, start tayo kay restitution. Ano nga ba ang restitution? It means restoration of property previously taken away. So, it is the restoration or the returning of the object of the crime to the injured party. Okay? So, the thing itself shall be restored, even though it be found in the possession of a third person who has acquired it by lawful means. Another is the reparation of the damage caused. So this one, it refers to the payment by the offender of the value of the object of the crime, when such object can no longer be returned to the injured party. So, kapag sinabi nating reparation, ito yung nagbabayad ng, pagbabayad, ito yung magbabayad si offender para sa bagay na sinira or ninakaw or kinuha niya, lalo na kung hindi niya na kayang ibalik sa may-ari o yung mismong bagay na yon. Okay? Para mas malinaw, isipin niyo ito. Kung ninakaw o sinira ni Pogi ang cellphone ni Beauty at hindi niya na ito maibabalik kang Beauty kasi yun nga, nasira na yung cellphone. So, kailangan na lang bayaran ni Pogi si Beauty sa halaga ng cellphone na yon. Okay? Paano malalaman ang halaga ng damage or ng danyos? Tagalog, danyos. So the court determines the amount of damage upon which the court may give due consideration. Dalawa yung bibigyan niya ng konsiderasyon. The price of the thing. Okay? Yung presyo ng bagay. Kung magkano talaga ang halaga ng cellphone o nung pinalitan na gamit. Okay? And yung second thing to consider by the court, okay, of course, siya yung magko-consider, sentimental value, among others. Meaning, i-consider din yung sentimental value. Kung may special na halaga ba o kahulugan ito kay victim or kay beauty, tulad ng isang family heirloom or regalo, mga ganon. Okay? So, hindi lang monetary value ang tinitignan, kundi pati na rin ang emotional or sentimental value ng bagay na inayos. So, lastly, criminal liability includes indemnification for consequential damages. So, this refers to the consequential damages, which includes the payment of other damages that may have been caused to the injured party. So, this further includes the damages suffered by the family of the injured party or by a third person by reason of the crime. Okay? Ito naman yung tumutukoy sa mga danyos na bunga ng krimen o mga pinsalang dulot ng pagkakaroon ng criminal liability. Okay. Hindi lang yun mismong ninakaw o nasirang gamit. Hindi lang yun yung dapat i-restore at hindi lang din reparation. Kasama din yung iba pang natamo ng biktima or ng pamilya ng biktima o ng taong involved. Anyway, halimbawa, kung ninakaw ni Pogi ang sasakyan ni Beauty at dahil dito hindi nakapagtrabaho si Beauty at nawalan siya ng kita, wala siyang income on that day, dapat bayaran ni Pogi ang una, dapat bayaran din ni Pogi yung nawalang kita or income ni Beauty on that day. Okay? Sa madaling salita, hindi lang ang mismong bagay o pinsala ang pinagbabayaran, kundi pati lahat ng resulta o epekto ng krimen sa biktima at sa mga taong malapit sa kanya. Okay, let's take another example. Ito. Inakaw ni Pogi yung sasakyan ni Beauty. Now, while he is driving, habang nagmamaneho siya gamit ang sasakyan ni Beauty, na-aksidente siya. And it caused damage to that car. Say, sabihin natin 50,000 pesos worth na damage sa sasakyan ni Beauty. Now, question, what is the obligation of Pogi to Beauty? So first, unang-una is to restore or return the car to Beauty. Second, to pay damages, which is amounting to 50,000 pesos. Kasi nagkaroon ng damage habang ninanakaw niya. So, 50,000 pesos, kailangan bayaran niya rin yun. And third, which is the consequential damages suffered by Ganda and his family. Kung magkano man yun. Okay? So, in summary, tandaan lang natin yung criminal liability is not just about jail or mapupunta sa kulungan yung may sala. It also includes paying of fines, and it also includes civil liability, which is restitution. Ano yung restitution? Ang pagbabalik ng property o nawalang ng property mismo sa biktima. Second, reparation of the damage cost. So, pagbabayad para sa nasira o nawalang bagay. And third is the indemnification for consequential damages. Pagbabayad sa iba pang pinsala na resulta ng krimen sa biktima o kanyang pamilya. Okay? So, last, Article 1162. Obligations derived from Quasi-Delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. So, obligation arising from Quasi-Delicts, okay? Let's dive into another source of obligation, Quasi-Delict, o ang tinatawag nating culpa aquiliana. Pareho lang yan, Quasi-Delicts or culpa aquiliana. Otherwise known as the obligation ex quasi-delicto or ex quasi-maleficio. Pareho. It refers to this, okay? Yung mga obligation that arises from the damage caused to another through an act or omission, there being fault or negligence, but no contractual relation exists between the parties. Tandaan nyo yun, okay? So, ang quasi-delict ay isang uri ng obligasyon na nagmumula sa pinsalang nagawa ng isang tao sa dahil sa kanyang aksyon or kapabayaan. Okay? An act or omission. Kahit na and there is no contract between the parties. Halimbawa, kung may taong nakasira sa gamit ng iba dahil sa kapabayaan niya, okay, through negligence, pero walang kontrata. Pero kailangan niyang panagutan yung pinsala niya kasi kahit na wala pang kontrata, kailangan niyang panagutan dahil nagawa niya yun dahil sa kanyang negligence. It was committed through, di ba, fault or negligence, that is quasi-delict or culpa-kiliana. Anyway, to better understand, eto yung requisites ni quasi-delict or ni culpa-kiliana. Number 1, there must be an act or omission. May ginawa o hindi ginawa ang isang tao. Second, such act or omission causes damage to another. So, dahil sa action or kakulangan o hindi paggawa, may nasaktan o may nasira. Okay? And third, such act or omission is caused by fault or negligence. Hindi sinasadya or dahil sa fault or negligence. And ang importante, number 4, there is no pending pre-existing contractual relation between the parties. Walang legal na kasunduan or kontrata sa kanila. Okay? Tandaan nyo yun. So, negligence, anyway, sabi ko nga, it is committed through negligence fault or negligence fault. Dapat may mistake. Negligence, ano ba yung negligence? This is the omission of that diligence which is required by the circumstances of person, place, and time. Ang negligence ay isang kapabayaan or kapag hindi mo ginawa ang hindi ka umakto sa paraang merong tinatawag nating tamang pag-iingat na inaasahan sa iyo ayon sa lugar, oras, at sitwasyon na yon. So, there are 3 kinds of negligence. We have culpa-kiliana, culpa-contractual, or culpa-criminal. And this culpa-kiliana refers to this first, okay, as a source of an obligation itself. Anyway, negligence per se does not give rise to quasi-delict unless there is injury. Tandaan nyo rin, okay? Yung kapabayaan mo, wala namang problema kung wala ding na-injured, walang damage na na-cause. Pero pag dahil sa iyong kapabayaan, nagkaroon ng damage, nagkaroon ng injury, then you will be liable, will have an obligation which is from quasi-delict or culpa-kiliana. Okay? So, let's take an example. Halimbawa, si Pogi, inutusan niya ang isang batang 10 years old pa lamang na umakyat sa isang puno na mataas at alam niyang madulas kasi kakagaling ng ulan. And ipinangako niya sa batang yon na bibigyan niya ng bunga or babayaran niya. Now, what if sa pag-akyat ng bata ng madulas at mataas na puno, nahulog yung bata at namatay? Ang tanong, may pananagutan ba si Pogi? The answer is yes. Bakit? Dahil Pogi is actually negligent. Pogi is actually negligent in making the order. His act was clearly a departure from the standard conduct required of a prudent man. Kumbaga, ang kanyang aksyon ay labas sa tamang pag-iingat na inaasahan mula sa isang maingat na tao. So, in summary, ang quasi-delict or culpa-kiliana ay nagiging sanhi ng obligasyon kapag may pinsalang nagawa. Okay? Kapag yung negligence or kapag yung fault or negligence ng isang tao, it causes damages or injury to another, then he will be liable, magkakaroon ng obligation. Pero kung wala naman, then maswerte siya. Okay? So, that's it. That's okay. So, tapos na tayo. We have done the sources of obligations. Sana nga naintindihan nyo kasi feeling ko minamadali ba o hindi. Anyway, feeling ko as in kahit hindi ko pa i-discuss, alam na alam nyo na at naiintindihan nyo na. Ako na nga lang ata yung hindi pa nakakaintindi. Okay? So, thank you for watching until this point and so sana suportahan nyo pa rin ako if ever mag-discuss ako ng iba pang subjects, I don't know pa lang kung ano yung susunod, okay? So, thank you! Bye-bye!